Hello.
Hello and welcome once again. We wish you a very good evening and we welcome you to Vestralex free online community classes on law. This is a free legal literacy initiative by you, for you, and possible only through the generous contribution of our seniors who take the time out to guide us to unique topics of law. Today, we have with us Shri Anand Grover, sir. He's a designated senior advocate practicing at the Supreme Court of India. He is the director of Lawyers Collective India and the former United Nations Special Rapporteur on the right of everyone to enjoyment of the highest attainable standards of physical and mental health. In his regular practice, Mr. Grover has argued several landmark cases in the field of public interest litigation, human rights laws, including mass eviction case of Olga Tellis versus Bombay Municipal Council, environmental law cases, the Bhopal gas disaster case, the LGBT rights, Naz Foundation case. Mr. Grover has also done innovative work in the field of patent law, opposing the grant of patents for essential life-saving drugs. He successfully argued the first constitutional challenge to Section 3D of the Patents Act 1970 on behalf of the Cancer Patients Aid Association in Novartis versus Union of India and the patent linkage case of Bayer versus Union of India. He was appointed the special public prosecutor in the 2G case by the Supreme Court of India. Sir, with folded arms, we very humbly and very warmly welcome you and request you to kindly take us through this very unique and interesting topic today.
Good evening to everybody. Thank you, Keshav. I will speak for about 35-40 minutes, and then we can have questions, and I have to leave at 5:30. Today's topic is towards same-sex marriage, but in order to understand that issue, it's very important to look at the historical circumstances in which the law developed and how the High Court of Delhi and the Supreme Court actually tackled the issues of same-sex relations. So we'll have to go back to history, and I think it's very important never to forget the history of India and the history of same-sex relations laws in India and elsewhere to come to an understanding of the present impasse on same-sex marriage. So historically, no, I don't know why it's not moving. Okay. Historically, in England, where we actually borrowed our Indian Penal Code, which is now transformed into BNS, which doesn't have that particular provision, it was same-sex relations were actually criminalized. And that's actually the basis of import in India, criminalizing of same-sex relations. People are now talking about other so-called invaders who have criminalized. It is not correct. I want to correct this historical falsification, as it were. It is only the British who brought criminal laws on a number of issues, including same-sex relations. So that was exported into India by the Indian Penal Code of 1861. And basically, it used the phrase unnatural sex, not defined, but it meant penile non-vaginal sex, which is non-procreative. And that was the Victorian morality, because in Victorian England, and even before that, from Elizabethan times, actually, sex was only to be had for procreation, that is to beget children, and otherwise not for pleasure. And it is this IPC which was replicated all over the world, and particularly the Commonwealth. And you see the same section 377 in Malaysia, Hong Kong, Singapore, etc., and other Commonwealth countries, including Kenya, Uganda, etc. So because of the criminalization, there were a lot of problems in India. And I came across this in 1997 when I found that large number of people were coming to my office who were into same-sex relationships. They were actually facing violence, torture, even murder, blackmail by lovers, police, and parents, persecution by a lot of people, shame and public humiliation, and basically not being able to live as they were, namely gay or homosexual. They were actually made to have two lives in the same day. Daytime, they were so-called heterosexuals, and in the nighttime, they could be what they wanted to be with their with their gay friends, as it were, basically leading a double life, and actually it impaired their dignity. And we got a lot of that information from 1997 to 2000 in the Lawyers Collective, and when we decided to challenge the law, that is 377 of the IPC in the Delhi High Court. So one of the other reasons we could do that was because I was working on HIV. And in fact, in HIV, people who are men having sex with men had high rates of HIV because, not because they were gay, because please appreciate that penile non-vaginal sex is not only engaged in by gay people, gay men, but also heterosexual couples. So penile oral sex, penile anal sex is actually engaged by heterosexual couples, which I mean, if you find that amazing, please look at anything on sexual literature, in sexual literature, and you'll find that that is the case. But people who are men having sex with men, there no services were available for them to protect themselves, including condoms. And amongst transgender communities, which are basically in our society, India and the whole of South Asia, Southeast Asia, the Hijra and the other communities, they actually were transgender men uh, uh, having severed their penis because of other religious understanding of their nature of being. They were not also protected. So, if there was any anal STD, which was common, they would be reported to the police. Then services actually became available later because of HIV. That is how I got involved in HIV and came to know a lot about um, uh, transgender people. But in India, unlike Europe, please appreciate, and all traditional communities actually were very much like India. You had the notion of third sex, Tritya Prakriti, in the Brahminical, Buddhist, and Jain texts. And actually, they are elaborated very well in all these texts. But in Jain texts, unlike Buddhist and Hindu texts, the notion of sexuality was understood as a psychological aspect of a person. Whereas in the Hindu and Buddhist text, it was mostly understood as a physical trait. So it's interesting. If you want to read about that, there are quite a lot of books available on this issue. And not only that, it is not amongst Hindus and Buddhists and Jains that same sex was tolerated or third nature was tolerated. Even amongst Mughals, the courtly traditions in the Islamic world, Ottoman Empire, Mughal India, actually it was very common for transgender people and people of having same-sex relationships. This is a thing that is not understood, and people have notions that in Islam it's prohibited. It's prohibited only to a certain extent, and it was tolerated historically. Now, this is very important about hijras because or the hijra and the larger community of transgenders. It's basically that they did not consider a sexual aspect of the person being binary, but more particularly because they actually entered the clan, the Gharana, and they actually castrated themselves. They were not men. But because they did not have menstruation, they were not considered to be women. So they were neither men nor women, and they were the third nature or Tritya Prakriti. So that is important to understand. As I've mentioned in the slide, Serena Nanda's book is very important in this. Please have a look at it and you'll get to know what this is about. But as far as 377 IPC was concerned, the language itself is very interesting. Whoever voluntarily has carnal intercourse against the order of nature with any man, woman, or an animal. So, carnal intercourse against the order of nature, this is a critical. They shall be punishable with transportation for life, life imprisonment, or either description, which may extend to 10 years or fine. So, this prohibited sexual act could be indulged in by a man woman or a man woman having it with an animal. So it was not against only gay men. But very importantly, penetration was very important. It was sufficient to constitute the act. So basically, it was penile penetration in any of the orifice of the other person, either the mouth or the anus, because they are no non-procreative acts. If it is penile vaginal, it is a procreative act. So penile anal, penile oral were the prohibited sexual activities under this section. And ultimately, the Supreme Court even said that rubbing the penis between the thighs is also criminal. It started to extend it, though in criminal law you can't do that. But because of the prejudice we imbibed from the British, we imbibed and we actually let go of our own culture, and we imbibed the British notions of sexuality, and the judges of the courts, including the Supreme Court, started extending the coverage of this section, as I said, to even penis rubbing between the thighs. So that's not an orifice. So it shows how you can be ideologically influenced by particular understanding of particular relationships. Now, very interestingly, the first case that went to the court shows the prejudice. It was against what we call transgender or hijiras. Khairiti was one such person. She was picked, or he was picked up. A transgender person was picked up, Khairiti, only because, according to the police, the anus of Khairiti showed that Khairiti was exposed to anal sexual intercourse. Now, as you know, the explanation to 377 says penetration is sufficient to constitute the offense. So you have to show penetration. If there's no penetration in evidence, then there's no offense. But despite the fact that there was no evidence, but the examination of the anus of Khairiti, according to the prosecution, showed habituated to anal sexual intercourse, Khairiti was actually convicted and sentenced. It's only an appeal that the Court of Appeal said, oh, sorry, you can't be convicted if there's no act. And Khairiti was actually then acquitted. What I'm trying to tell you is the prejudice was so strong that Khairiti was convicted despite the fact there was no case for the prosecution. And that goes on in a number of situations where people have prejudice against a particular group or communities. And the prejudice against gay men, LGBTQI still continues. Now, what happened was that because of HIV, and I can tell you from personal experience that because of HIV, we needed to actually prevent the transmission of HIV. And there were some very, very important measures taken at the instance of large number of very intelligent, scientifically minded people who advised the government that you have to take radical measures, which meant including, make sure that you give condoms to people, including gay men, transgender men, male prostitutes, sex workers, etc. Excuse me. So that actually brought us across a large number of the gay men, transgender persons, etc. And networks were set up, and condom promotion became one of the major instrumentalities to prevent HIV, and it worked. We were able to succeed in preventing the transmission of HIV in that strategy, unlike the strategy which was being advocated at that time. And I may tell you that people said that those people who are HIV positive, they should not be allowed to marry, they should be ostracized, they should be sent to another place, etc. But we were able to do and actually succeed in stopping HIV, preventing HIV from being transmitted largely. And now, by the next decade, we'll have actually eliminated the transmission of HIV because of a scientific approach. It is one of the only ailments which was approached on scientific basis and controlled. So it's a very good example of seeing how you can actually do it. But for the transgender gay community, HIV services became safe havens. And we could actually ensure that counseling was done, condoms were made available. And for drug users, the radical strategy was, especially for injecting drug users, to actually make them available a fresh needle. Please appreciate, and take the old needle back. And those people said, no, you're encouraging. But actually, we were preventing, because the person who had the needle, he or she would actually share the needle. So increase the chance of transmission. So all these things, coupled with the fact that from in the international arena from 1995 and in India from 2004, you had the treatment for HIV, which is known as antiretroviral therapy, combination of three drugs, which actually started preventing not only new infections, but also made sure that people who had infections could live normally. So these are also important lessons. Now, in 1997, as I said, I came across lots of gay men because we had done a very important case in HIV called MXOCZY. It was about a casual worker in public sector corporation who we could get reinstated in a public sector corporation, though he was HIV positive because of the case that was argued. And later on, we drafted the HIV bill, and the HIV bill was modeled on some of these lessons from courts. And HIV is intimately connected to the gay rights movement. People don't want to know that because they think, oh, well, HIV positive people are with disease and gay men are not. It's not correct. Right across the world, HIV was a key area which allowed them to come out, be in safe places and spaces, and make sure that they could be treated, etc., etc. But that case was actually splashed all over. And because of that, a lot of gay men started coming to our office of the Lawyers Collective in Mumbai. And ultimately, I've told you this before, we decided to challenge the constitutional validity of Section 377 in the High Court. And we relied on some of the judgments which were rendered holding similar section, in fact, the same Section 377 in the Commonwealth, Hong Kong, Fiji, but not in the US, which had actually struck down those sections or read them down. We were asking for reading them down because there was no protection for children if the section would have been struck down completely. So in Naz Foundation, we argued that 377 is violative of Article 14, which is about equal treatment and equal protection of laws, because it's vague, arbitrary. Nobody understands, acts against the order of nature. It's not spelled out. It's vague. How do you know what it is? And it affects, though it is meant to be for every person, including women, it was only used against homosexuals. Then Article 15, because that includes the term sex, which we said is gender. So sex includes gender, and there are precedents for that. It also meant free speech under Article 19(1)(a), because a person who free speech included the way I dress. If I'm a transgender person, my freedom of expression includes the way I dress. And then 21, which is very, very important, because it actually means, first of all, life and personal liberty. Liberty means autonomy and dignity, most important. And it's in the private sphere. What I do as a sexual being is all in my private sphere, intimate, personal sphere, where the state cannot intervene. And finally, it also impacted on the right to health. So that was upheld by the High Court, Delhi High Court, by Justice A.P. Shah, which also included privacy, sexual orientation, and saying that marginalized communities should be integrated into society. That's a very important emphasis that the Delhi High Court laid. And very importantly, it evolved the idea, or rather it emphasized the idea of constitutional morality, which is opposed to the notion of public morality. And it is drawn from earlier judgments and speeches. But constitutional morality is something which is derived from the Constitution. And it's opposed to the majoritarian notion of morality. So that verdict in 1997 was very, very important. And we called it the second independence for certain communities, because they had not got any freedom in the earlier real independence, as it were, which was much earlier. That was challenged later on in the Supreme Court. But in the meantime, I was asked to appear in a matter in Allahabad High Court on the case of Dr. Siras, now from Aligarh Muslim University. And you may be familiar with the fact that Aligarh is a film made on this case. I've not seen it, unfortunately. I just had no time. But it's based on this case where Dr. Siras was having a relationship with a rickshaw driver, a permanent relationship, not a casual one. And the press, which did not consider the sexual relation to be his private sphere, actually went into his home trying to film him with his partner. And ultimately, because that became public, the university suspended him. I went to the Allahabad High Court, got a suspension stayed, but unfortunately, because of other reasons, he died suddenly. We don't know why, and there's a lot of speculation on that. Ultimately, a film has been made, but this is an important follow-up from the Naz Foundation. As I said, in the meantime, appeals were filed by various people in the case ultimately known as Suresh Kumar Kaushal. And the Supreme Court ultimately set aside that judgment of the Naz Foundation. We filed a review. The review failed. We filed a curative petition which was pending. Then there was the Nalsa case, which is very, very important because it actually established for the first time the decision of the rights of transgender people. And then also, while 377 case in the review and the curative were going on, the government, through the then Attorney General, Mr. Rothke, who now appears for the petitioners, surprisingly, actually challenged whether Article 21 had privacy written into it. Now, these were very important changes that happened during the period of the pendency of the curative petition. The rape law was changed. Earlier, it was only penile vaginal penetration. Then it became everything, from touching, etc. Now, if you look at the rape law now, it includes every act. And very importantly, consensual acts were not penalized. And the child law also, chain POXO came in, which actually made it gender neutral. And then also the HIV bill we had drafted became law, and it actually promoted condom promotion and needle exchange in communities. Then the mental health law also was amended to actually recognize sexual orientation. So by the time the final matter in the form of Navte Johar, which actually was a writ petition, which was technically not maintainable, but anyway, the judges took it up. That's another story which I don't have to go into now. It also upheld the decision in Naz Foundation. So that was the basis, same Article 14, 19, and 21. So after that, naturally, what happened was the matter came about that why should the same-sex marriage amongst gay men not be recognized? And for that, we had the decision in the United States in the form of Oberfeld of the Supreme Court of the United States, where, very importantly, the right to marry was considered to be fundamental. Okay, and because the states had introduced laws in the US, the diverse states, criminalizing not allowing same-sex marriage or criminalizing them, the Supreme Court of the US actually held that those statutes premised on the notion the right to marry was fundamental was struck down. Now, in India, what happened was in Supriya Chakraborty, which is originally the matter was filed in the High Court, it was transferred to the Supreme Court. What are the arguments? The first argument was, in fact, that the right to marry is fundamental. Now, why? Very briefly, because not only has it been held by the same judge, Justice Chandrachud, who did not agree to the notion that right to marry is fundamental, in Shafiq Jahan, he actually held that it was fundamental. And it is fundamental on the basis of Article 19 and 21. essential right to privacy because of Puttaswamy, and also under the International Covenant on Civil and Political Rights, the right to found a family is recognized as a civil right, which is incorporated as a human rights instrument in India through the Human Rights Act. So we recognize and we incorporate that. So there was no way the court could have held that it's not a fundamental right, but it did. And then we also argued that non-recognition of the right to same-sex marriage actually is violated of the substantive due process under 21, etc. Also, that recognition of marriage was totally against the notion of constitutional democracy, because your marginalized communities need to be recognized for what they are, and also against constitutional morality, which was, as I said, in Naz Foundation. And also the objections to same-sex marriage on the ground of religion and faith has been negated because it is the basis in the same-sex marriage petitions that anti-discrimination is one of the notions of constitutional morality. But that was not agreed to because the respondents' arguments were actually agreed to, and they were very simply that granting the recognition to marriage is the matter of the legislature, and the courts do not have the wherewithal to decide these issues. The Constitution itself doesn't talk about the right to marriage, though they forgot that implicit rights have been recognized. Like the right to privacy is not explicitly mentioned in 21, but Puttaswamy by the 7-judge bench held it is. So the right to marry may not have been written into Article 21 or 19, but in the association, but the Covenant on Civil and Political Rights, which we have adopted, recognizes it. And then they said the marriage only is the creation of statutes, and the states have the power to actually lay down conditions, and therefore we are not going to allow the courts to decide it. And the conditions can be laid down which are actually for what they considered legitimate state interest. And there is no question of homosexual relationships to be for the states to have legitimacy. And they said now, because of Navteej Jawar and Naz Foundation, because same-sex relations have been decriminalized, therefore gay couples or lesbian couples can form relationships. But marriage is not a right, but a privilege. So that is the sum and substance of that case. So I have finished, as I said, in half an hour. I would invite questions. I have about 20 minutes, 20, 25, whatever you want. We can have a discussion. Thank you very much.
Certainly, sir. Thank you so much, sir. It was very enlightening. You took us through the entire, actually the sum and substance of it, from where it started, what the original problem was, until where we are right now. So, so just one thing I want to ask before I start taking questions which are there, and I request everyone to kindly just share your questions in the chat box. We've already received a few questions here, and I request like whatever is coming on WhatsApp, rather please just share it here only. The first thing is that it's a very delicate, very sensitive topic, this particular topic, and I'm very, very grateful to you for choosing to speak on it and for enlightening us. Because at the end of the day, all of these people are our only. So, what is the relevance of sex education for not just same-sex couples, but for couples and people in general in India?
Well, according to me, one of the major failures of the educational system is not to include sexual education or sex education. During HIV, because it was very, very important to have sex education, because HIV is transmitted by, amongst other methods, by sexual route. So, and that was a major route for heterosexual transmission. We thought it fit to advocate that sexual education is a must. So in fact, I used to go around to schools and colleges from 1997 around to 2004-05, going across schools, colleges, hospitals, advocating for sexual education. and we would talk to mothers and fathers and teachers about what sort of sexual acts people indulge in. It's very important for people to know what is sexual activity and what is the natural curiosity about it. As the child attains puberty, the child obviously um, gets urges naturally to examine sexuality and fondle with their own sexual organs, and that's perfectly natural. And children have to be educated about it so that they actually respect their partners in sexual relationships, and also taught about how to prevent disease. That is not being done now. It was done during a few years in HIV, which was very, very helpful in trying to control the epidemic. It's very important today that children learn about these issues. Otherwise, take for example, rape is increasing day by day. And why does rape occur? Rape is basically non-consensual intercourse with the other partner. In India, it's gender specific against a woman, but it could be gender neutral, and it should be over a period of time. But why does a person have sex non-consensually with another person? Because they don't respect them. Not only that, because they're not sexually educated, they can't approach other uh, persons or partners to have a consensual relationship. So it's a two double-edged sword, because they are neither given sexual education nor are they given education to respect the other sex. So that's one of the major reasons why rape is going from leaps and bounds, increasing every day. And by giving one death sentence and two and multiple death sentences is not going to change. You need to introduce sexual education very, very seriously. And amongst the topics that you will discuss in sexual education is gay relationships, same sex relationships, and tolerance towards that. Because even uh, I may be heterosexual, but my sexuality can change over a period of time. I can become from heterosexual to attracted to my own to my own sex. That's quite normal. It has history has documented a lot of these things. In fact, I was to give a lecture at Chicago Law School on homosexuality in Uganda. When I was reading through the literature, it was very difficult to find, because, like the Indians, the British has suppressed and inculcated and inducted the African populations into believing that they never had same-sex relationships. But then, once I got into the matter, I found a lot of literature which was old, which documented homosexuality as prevalent in all parts of Africa, like all parts of the world. And one of the things that I found very interesting was that sexuality can change over a period of time. Like, for example, I had sensitivity to gluten. Now I don't have it. So your attitudes, your notions can change. So don't be surprised if one day you're attracted to the same sex and you'll find, oh my God, what happened? That's perfectly natural. Nothing wrong with one person to think like that or feel like that. But and you have to be open to the ideas and not, and if you're educated, you won't feel frustrated or depressed. People are not educated sexually and they go into depression, which is a serious issue. So you're absolutely right that sexual education is a key, not only for understanding same-sex relations, but very importantly, avoiding and making sure that people respect each other, and consequently rape actually decreases rather than increases as it is happening today.
That's a very interesting point how you link it with rape also, because that way is also, so actually there's a lot of discussion that I think is required on sexual uh, uh, knowledge for people, how exactly, what exactly is the process, how exactly to do it in a good and in a, if not in a procreative manner, at least in a productive manner, rather than going through all of these
Yes.
unnecessary thoughts. But say in furtherance of that, with respect to how you mentioned that sexuality, a person may find that they have evolved in their sexuality. So I hear whatever. So today there's a lot of how do I say, same-sex relationships which are being discussed on OTT, on social media. A lot of people on, I would say, Instagram, Twitter, everywhere. There's very freely they've started speaking, even if not freely, then they're at least expressing their sexualities. What is the time, sir? How we've always, I think all of us have heard that time or that one particular statement which people say that you are born that way. So what is the difference where we see
No, you
on
see,
the
there's no real answer to that. I think a lot of people are born that way, but you can also have a tendency towards that during the course of your life. So it's not a matter of choice, it's inherent in you in that sense. It's not necessarily that you're born with it. You discover it later, maybe. But these are only moralistic arguments because once we realize that same-sex relationship is normal, why should you castigate it? The notion of you're born that way is to say, well, I'm helpless and therefore have empathy with me. That's not the basis of equality before law or equal protection of laws. Whether you are born or you're actually engaging in it for pleasure, recreation, it is a legitimate exercise of your private right. That's it. That's the end of it. There's no question of, they don't have to justify that my DNA is like that. Your DNA, if you're a man, is XY, So that DNA is not going to change. That's why it's very difficult to say it's nurture or nurture, nature or nurture. So I don't think these are important, these are relevant questions, but people want to do that to otherwise castigate. Oh, you can't help it, so we have to have empathy with you. That's not the way to go about it.
so would it mean that the more conversations we have on this topic, would that kind of influence people to
Yes.
probably look towards,
Yes,
would that
because
influence to
in
people
order,
to
you are
feel
absolutely right.
empathy?
In order to get rid of stigma, you have to talk about it. You have to interact with those persons. I always used to say with the communities of gay men, sex workers, drug users, etc. Stigma means I won't talk to them. Stigma means I won't sit on the same table with them. No, actually, if you want to overcome stigma, like in the caste-ridden society, if you want to get rid of stigma of caste, you should share food, wine, and drink with the same person. I have always found that if you talk on have a drink or whatever, maybe you're a teetotaler, but have dinner or lunch with those people of the different diverse caste or religion or community, sexual communities, whatever, you come to know of the other people. Otherwise, you're ignorant, an ignorant fool. It's very important for you to understand what other people are like. Excuse me.
Bless you, sir. Bless you, sir. You're feeling unwell, sir. I understand. So,
Yeah,
but still, you chose to conduct the class and continue it on time. So, deeply grateful to you for
yeah,
that.
no, I'm okay. So there's a question I see
So,
on the chat box.
yes, sir. It says, so this is by Miss Samita Dikshit. She says, my question is restricted to legalizing same-sex marriage. If we go by the word of Hindu Marriage Act, or for that matter, Islamic practice of nikah, the legality of both lies on consenting of legal competence, groom and bride. Thus, why cannot we enact a special marriage act wholly committed to legalize same sex marriage, as it would allow them not only the right to have children by adoption or surrogacy, streamline the inheritance laws for them, as well as rights of partners? A special act just for these individuals in the way ahead, but unless we have a legislative intent, we will, okay, so this goes on to into opinion. So I think primarily where she wants to hit is that can there be a special act which can be enacted?
You can have a special act, but legally that's not required. You can amend the present laws, but the point is that the legislatures, either the states, both have the competence, or parliament, can actually introduce a law if they want to, but they don't want to. It's the legislative will which is lacking because of the ideological position that parties have adopted. The ruling party has adopted a position that same-sex marriages should not be countenanced and they should not be recognized. They're not, according to them, a legitimate state interest, so they can't be protected. So, in my opinion, the Supreme Court should have interpreted the International Covenant read into Article 21 and 19 to say that it is a fundamental right to marry and not allowing same-sex marriage to be legalized would in fact be violative of the fundamental rights, and therefore edge or nudge legislatures to enact a law or just give recognition by a court order. That didn't happen, and then there's a long road for the community to get it legitimized and recognized. But the last sentence actually betrays the real situation today. The legislatures don't want to change. They have adopted the English notion, which is traditional English notion is criminalize same-sex relation. That's what they're adopting. They're becoming more English than the English. Whereas the English changed only later in the 19th century, or the 20th century, sorry, 1957, when the Wolfden Committee actually recommended the decriminalization of same-sex relations. They are going back to the earlier notion of the English custom, law, and beliefs and morality. It's Christian morality that we are following today in India.
So is it more of a religious thing that is whatever?
Is religion driven by political ideology? I think, I don't know, but it's wrong. Whatever it is, now it's against what we call constitutional morality.
So is there any sort of actually? So there are a lot of questions with what ma'am has just asked. So there are a lot of questions in that which I wanted to touch upon with you also.
I can't see any of them.
Uh, no, sir, not over here, sir. Actually, sir, what is happening, sir, I'll be very honest with you. I did not know before having this topic what this topic would imply. Sir, we've shared it with I don't know how many people, and so for the first time ever, we had more number of people leaving our group after we shared this particular topic than the number of people who were joining. So I found it very fascinating, very interesting. People do not look at it at this particular topic very, how do I say, at least empathy I could not find, but I'm just trying to explore the reasons so that probably, hopefully tomorrow there can be some sort of a better, whatever manner in which it can be better for people. So, sir, with respect to
I have another 15 minutes.
certainly, sir, just a few more questions. I'll just take in, sir. I understand your health is also.
No, I'm not bothered about my. Don't worry about it.
So, with respect to since homosexuality today is legitimate and legalized, so in that case, if two people they want to live together over a longer period of time, what is their, how can they probably have some sort of, progeny, some children? Can they have some sort of children in any manner whatsoever?
They can't beget they can have their children by surrogacy, but their relationship will be not considered to be a marriage. That's the major problem. That's what actually gives a lot of other rights, which is what the gay community wanted, and they could not get it. Including inheritance of the property. If you're married, the successor is your partner, legally married. That's not available. Adoption is a major issue. So if you get married abroad, get adopted abroad, then the question is open whether it's recognized in India. But it's going to happen sooner or later. I'm very confident there's no way you can prevent this. There'll be more and more. It'll happen within the ruling dispensation. Sorry, but I'm gay. I want to. So there'll be pressure from within the ruling dispensation, not only today, but it may be the next, whoever, within the ruling echelons, it changes over a period of time because it's natural to be gay, and it'll be within the ruling dispensation also. Will then pressurize their own peers to say, sorry, this thing is wrong, let's change it. It'll happen.
So is there any statistical data which points out to how many people identify as LGBTQAI individually or probably under each and every head?
It's not totally. I mean, there is data, but it's guesstimate. It's a guesstimate. There are data on self-identification is one thing, but the other thing is about who have sexual relationships. The people who have sexual relations are people who are considered to be men having sex with men, but people who are identified as gay, they are a smaller group. But it's a huge percentage. It's not a small percentage, running up to 9,
So I
10%.
think Mr. Dhananjay also have a question. Dhananjay ji, please ask.
Please, sir. So I find it slight.
Name is Anand Grover. You don't have to be formal.
Please.
That's a
So what? So
British
you're just
notion.
too kind and
Sir,
humble.
sir is a very British notion.
Okay. So my question is that now in our relation or marriage between men and women, there is a set laws which prevail. For instance, domestic violence, DV, domestic violence 125, and etc. and etc. So how do one see in a same-sex marriage that if there is any sort of violence that is being committed by other partner, so how these issues will be addressed, or how to approach these sort of issues, sir?
No,
In
no,
a
no. Once that marriage is recognized, they will just follow. That's all. Because, except for the fact, if that law is gender specific, like rape law, that won't follow. Okay? If domestic violence is gender specific, it won't follow. But over a period of time, there is no doubt in my mind that even gender specific rape law will change because there is violence amongst the gay community. One partner committing violence against the other. It's actually natural. You know, violence is, I won't say violence is natural to human beings, but it happens as a common instance. So let us assume that you actually change the law and same-sex marriage is recognized. Then all the laws which actually apply to marriages, except if they're gender specific, will follow. So, you know, therefore, and they will also be amended over a period of time. But the question is, how long will it take? But otherwise, you have recourse to ordinary criminal law. If you're beaten up, you know, you are entitled to go and file a police complaint
yes.
on assault, battery, etc., etc.
My point, so my question was more inclined towards the financial aspect of a relationship. For instance, in
Once
a
marriage is recognized, then financially, because then inheritance law, laws relating to common property, they become applicable. If you go to a bank, you have a joint account, and one person dies, the inheritance will follow, because then you can be recognized as a man and a woman in terms of what role you perform. So that will become very easy. Even today, two gay men can have a joint account. But if you say you are gay and the bank clerk says, oh, I'm not going to allow that, that's an individualistic notion. But a joint account by two people cannot be prohibited. Okay. But if you die, if you are a married person and inheritance laws applies to you, whether you follow a particular religion and therefore that particular law applies, automatically those things happen on death of one of the partners. That and also benefits. So many benefits you get because of your marriage to another person. And also, very importantly, emotionally, you are in a comfort zone that you can rely on your partner to do so many things. Like a married man in a heterosexual relationship can rely on his or her partner to be able to support him or her. That is it's not only physical support, it's emotional support. When you go through trials and tribulations of a marriage and of life, you need support from each other. I can see you're a lawyer. I can see law books behind you. Like when
yes,
you're going through a difficult time and you have somebody to support you emotionally, give a bit of comfort, you know that you can succeed because there's somebody supporting you. That is an important part of a relationship. And marriage gives that lot in a large measure. So marriage is not only for sex, it's also for huge amount of comfort from the partner.
thank you, sir.
Thank you, Dhananjay ji. Sir, there's this question from Mr. Virendra. Virendra ji, आपका question, please, sir. I request you to ask.
Yes, it was not more of a question. It was rather an opinion on the approach government has taken in the recent legal changes, the legal reform, the BNS and BNSS were introduced. Government should have taken more, particular view and maybe could have made some changes in the legislation to include some light on this special category. The way forward can be first to identify how many people are within the scope of this, regime change we are asking, or the legal change we are asking. The best way to find that out is to include that in your census surveys. See what percentage of your population is within that category.
Absolutely,
People
sir.
will be open to
जाति जनगणना से तो better है कि at least 50 करोड़ लोग
So
or
it
they
can
are
be clubbed with that. So if you want to later on introduce a caste basis census as well, you can club that with the sex orientation as well, and do it in a combined manner. You will clearly know how many people are within the scope. Accordingly, see whether you need a special law for that, or you can mainly amend the basic laws, the criminal laws to
so so
accordingly
uh,
make the changes.
so I'll just Virendra sir, I'll just try to quantify your question. Sir, Anand sir, would it make sense to have uh, some sort of a census-based inclusion of uh, such people who identify themselves as LGBTQAI+++ into the mainstream laws of today?
Well, first of all, please remember, there's no decadal census for last 10 years. Okay?
Yeah, it doesn't
Last
happen.
census has not happened. Now, there is going to be a census. According to the latest statement by the government of India, there is going to be a census. Now, in that, all categories should be identified. There's no reason why. Because people identify as such, they should be also part of the census. The second thing is, I agree with Virendraji that in fact, the BNS and BNSS are a total lost opportunity on a number of fronts. For example, the expression man could actually include woman or transgender or same-sex people. That's not done. Because actually the three laws have not really done anything new. They are a rehash of the old law. It's a renumbering of the section is what the parliamentary committee said. And the only changes are very minor. And the deleterious changes are about length of imprisonment and increasing offenses. Because actually that's worse than the British, you know. The British did not have so many offenses. And now you're using these criminal laws against your own people, which the British didn't do. So it's not a progressive piece of legislation. It's not anti-colonial. Actually, colonial legislations are those which are used to suppress people by criminal laws. Unfortunately, we have more of that. So whether it's right to call it anti-colonial or not is an open question, and I would strongly disagree with that. But that's a I mean I
That's
can
a separate
discuss
topic, sir.
that. That is one of my
That's
areas, but it's not a remit of today's discussion.
but so if I may just
Thanks.
from his question, Virendra ji, say from his question, if I may just lead towards a different issue, uh, absolutely over there itself. That's something like a sexual harassment of women at workplace prevention prohibition redressal act. So over there it says that if a woman employee is harassed by a male employee. Now, sir, I ask if a woman employee is harassed by a woman boss, or if a male employee is harassed by a male boss, like that does not come under this ambit, but in that case also if on the streets, let's assume, like let's since we're speaking of how do I say sex education, so in that respect itself, sir, so if there is if it is understood that men are committing rapes, so sir, men may start committing rapes on men also.
They are They are you mean gay men commit rape on gay men, but does not constitute rape because it's gender specific. So there is a need to change the law on that front also. Again, that's a lost opportunity. And sexual harassment at the workplace also a lost opportunity. You don't see the women's movement say that rape has always been historically against women, which is correct, but also against gay men and also transgender. So you need to include that somehow. And the first step, I think Virendra ji is correct. The first step is to include the identification of these categories in the census, the national decadal census. I hope it happens because a lot of our data and
um, is sir's video paused, video and audio only for me, or is it for everyone?
It is paused.
It is paused. Okay. I'll just have a short word with her. But yes, very interesting actually this topic. So I'll just join you guys shortly. He's back. So please, actually, sir, the light is also gone behind you. So you're on mute. Anand sir?
We can take the last question.
Yes, yes. So, sir, last question is only with respect to way forward, with respect to empathizing the entire sphere of individual choices and liberties, whilst also empathizing with the fact that there are a lot of people for whom it's an absolutely new and novel concept. So, how does people who really identify, who genuinely identify as uh, biologically, who identify as LGBTQAI plus plus plus,
Well,
and
I
people who are scared because there's a very big concept of homophobia also. So how may affect the confidence building measures for everyone
I
in
think
an
it's important.
amicable environment?
Well, exactly. You have to have an enabling environment. You have to make spaces friendly for people who are in that community, like you should have for every community. Every community which is separate, identified, you should have a safe space for those communities, whether it's sexual, religious, caste, whatever. Everybody should feel comfortable. And those who are in administration, like even say residence welfare societies, they can have a night, evening to meet gay men or gay people. Why not? That should be a great idea. We have gay who are openly gay, they would like to meet you, and then make an atmosphere which is conducive to their staying in the colony or whatever. If there are communities of particular group who feel suppressed, bring them out, make sure that you are friendly to them and there's a space, safe space for them, and they need not meet other people, they can come there and seek help. That's how you change society. And we've done that with HIV, drug users, sex workers, and make them feel at home, make them feel part of the nation, make them feel part of the community. That's how you change things. And people who are in the lead in the administration, they should actually be setting an example.
But only one thing, sir, where everything I think comes down to is with respect to the fear which a lot of people have
So that's
with
why
respect to people who have LGBTQAI plus theories, simply because of the fact that they feel that our children or us personally, that either we may be become victims of any form of harassment from them, or maybe our children may be brainwashed into becoming, into changing or exploring identities for themselves.
no, first of all, I think you should have some sort of meetings with people who are, people who are in the main community so that they come to know what is the reality, what is actually happening, not having fanciful ideas of changing a child's sexuality. You can't change people's sexuality. But I think friendly spaces are very important, and educating the majority community, as it were, is very important.
So, sir,
In the legal community, the SCBA should be taking a lead. They are in administration. Why don't they hold a meeting just to, a gay night? Why can't they hold it? Unfortunately, we don't have people who.
I would really, so I request you to kindly put that thing forward. So it
I'm
would be
going to put it.
really interesting
I'm going
to
to.
see.
Okay, we'll have to stop now.
So your light is also going. So next time around, I request you kindly, sir, that the light actually we wanted to check, but
No,
light.
we had a major power breakdown here.
Oh, okay.
That's why. Okay.
Kind of you to still take
Okay.
the time out and take that initiative. The
Okay.
deepest gratitude to you. We hope that some other people may get benefit from this session today.
Thank
And
you.
so sincerest gratitude to you.
Thank
And
you very much. Take care.
Thank,
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 Have a
thank
thank,
you
good
so
one.
much. Thank you so much, sir. So
thank,
I seek
thanks
your
all.
permission to end the class.
So I enjoyed it. Yeah.
Thank you so much, sir. So to everyone who is with us so far, thank you so much. We hope that you found something of value in this class. We hope that whatever your doubts are, at least to some extent, they would have gotten aligned to some extent. At the same time, we request you. It's a very humble free legal literacy initiative. We're trying to have a conversation around things legal. So, in that respect itself, we request you to kindly support the initiative. There are a lot of other topics that we've spoken upon, but this is absolutely the benefit for us of doing these things is that we also get to learn. So, before taking this topic, I had different ideas, but after we had the topic, after we sent out all the invitations, then I got to see a very different perspective and reality of how people perceive these things. So if you're a person of this community, request you to kindly be patient, and obviously we just go through the process, patience, perseverance. I think all classes, all of law, everything we've understood is that it comes towards there. And at the same time, just please request you to kindly like the video, share, subscribe, and at the same time, just be happy, right? So thank you so much to everyone who's been with us today on this very interesting and unique topic, and we wish you a wonderful weekend, and Jai Hind, Jai